Section 41 of Criminal Investigation, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Larry Wilson. Criminal Investigation, a Practical Handbook for Magistrates, Police Officers, and Lawyers, Volume 1, by Hans Gross. Translated by John Adam and John Collyer Adam. The Expert and How to Make Use of Him, continued. Section 10. Arthropometry Bertillon System. The Bertillon system of measurement, known as arthropometry, or Berlinage, has since the first edition of this book, 1892, come into tremendous favor, though at first it was, like every new thing, vigorously opposed as needless and absurd, and was even put down as a complete swindle by certain ignorant persons. Today, however, the system is in full swing, and no modern police force thinks of underrating its value. There is, however, one difficulty which people have created for themselves, arising from the many so-called improvements which have been grafted on to the system. No one can maintain that Bertillon perfected his system right away, leaving it incapable of improvement, but it must be admitted that that gifted investigator avoided everything absolutely unnecessary and inexpedient. The author has for years pointed out that the real value of the Bertillon's system lies in its internationality, that is, in its general applicability to all races. This, however, can only work smoothly when alterations and improvements are as much as possible discarded, so that the dispatch of a row of figures will be sufficient to enlighten the police at the other side of the world. It will not then be necessary to telegraph size X, seat height Y, span Z, but merely XYZ. If, however, the foot length, for instance, is omitted in a description, and the circumference of the knee is substituted therefor, confusion will result. Bertillon, in originating the theory, was cleverer than all his predecessors, and he is also cleverer than all his successors. Things should be left as he has arranged them, and in this way alone will important results be obtained. The greatest enemies of a good innovation are those who seek to improve it out of existence. By arthropometry is generally understood the most rational method of measuring the dimensions of the human body, in order to establish the identity of an individual. We are already dealing with embryonic anthropometry when we indicate a person's height and his distinctive signs, such as extraordinarily large or small hands or feet, also when we compare footprints and fingerprints. But the science took a remarkable leap forward when M. Alphonse Bertillon of Paris introduced the employment of anthropometry into the police department for the recognition of old offenders sailing under false colors. In this science the great thing to determine is what parts of the body should be measured. The reply is, in an adult everything is measured which does not change, that is, everything which depends for measurement upon the bone and cartilages. The muscular fibers, the fat, the ganglions alter even in a short time. The bones and cartilages, on the contrary, preserve their dimensions permanently except in very rare cases. The following measurements should therefore be taken: the total height of the body, the height of the bust, the sitting height from the chair to the top of the head, the distance between the tip of the middle finger of one hand and that of the other when the arms are extended horizontally, the lengths of the forearm, the foot, the thigh, and the different fingers. Also certain diameters of the head, especially the circumference, just above the ears, and the depth, from the forehead to the nape of the neck, the dimension of the nose and both ears, the last often showing great differences. It goes without saying that special instruments and a certain amount of skill are necessary to take these measurements promptly and accurately. There must be a special police department, as in Paris, where these measurements are taken, docketed and pigeonholed. Gradually such offices will be opened everywhere. To the Investigating Officer their utility is indisputable and their application well nigh universal. But in cases in which Investigating Officers find it necessary to take those measurements themselves, it must be noted that old measurements not appertaining to the bones and cartilages are deceptive, and that the dimensions should always be taken with a rigid square, measurements with a tape not being admissible. If therefore we measure the height of a man, he must be placed against a wall and a rectangular piece of wood placed upon his head, one side of which directly touches the wall, while the other is held firmly on the top of the head. In measuring the length of the foot, it is placed on the ground, and exactly against the heel and the big toe four-sided bodies are placed, e.g., a little box, a big book, a brick, etc. The sides of the two rectangular bodies, which face one another, should be parallel, and the distance between them is measured. If we were to measure the tape, a false measure would be easily obtained, for it is difficult to determine the beginning and the end of the measure, and moreover the tape often has to pass over places which are not straight and not always the same. In taking measurements on photographs they must, to ensure accuracy, be considerably enlarged. It is not absolutely necessary for the photographs to be of equal size, for in finding out the relative measurements it is easy to compare them, but it is absolutely necessary to make the enlargements with the same camera, so that the distortions which may possibly take place may be the same for both. In taking the measurements it is good to commence with the dimensions of the whole face and then pass to the various features. Special attention must be paid to the dimensions and details of the ears, which are as a rule very characteristic. But it rarely happens that the Investigating Officer is himself driven to take these measurements. He will only have to do so when measurements taken by anthropometrical agencies have been communicated to him. To give an idea of the method of procedure of these institutions, we cannot do better than refer to the works of Bertillon, Appendix to Anthropometrical Classification and Identification. In the chapter in which the author explains how the photographs in the possession of Paris police are utilized, he tells us that the Paris police had in 1893 about 120,000 photographs of Parisian criminals. When a criminal is arrested, the first thing to be done is to find out whether he is an old offender. If he is, his photograph will be found in the album of criminals. The first step is to ask the gentleman's name, which if he gives correctly, his photograph is soon found. But if it cannot be found under the name given, it must be looked for in the album under another name. It goes without saying that it is impossible to verify 120,000 photographs each time a Paris criminal is arrested. The process is therefore methodical. Firstly, the measurements of the individual arrested are taken. Now from the 120,000 photographs, 30,000 may be subtracted right away as being those of persons under 20 years of age. The remaining 90,000 are divided into three groups, and each of these three groups is subdivided into three others, and each of these latter into three more, and so on. In the first place, the 90,000 photographs are divided into three series of 30,000 each, according to the length of the head, which is either large, medium, or small. Each of these series comprises three groups of approximately 10,000, based upon the breadth of the head, which also may be large, medium, or small, and each of these groups is again divided into three, according to whether the middle finger is large, medium, or small, each group containing about 3,333 photographs. The three different lengths of the foot again divide each of these three groups into three other composing 1,111 photographs, which are subdivided according to the length of the forearm into groups of about 370. These latter are further divided according to the height of the person into three groups of about 120. The last group of 120 is not subdivided into three as before, but split up according to the color of the eyes, the length of the little finger, the span of the extended arms, the height of the bust, etc., till we obtain groups of about 10 photographs in which we search for our man. It goes without saying that fixed measures must be established for the various groups. It must, for example, be well understood what is meant by large, medium, and small length of the foot, so that absolutely no ambiguity may arise. Let us take an example. The man's head is A millimeters in length. He therefore belongs to the group of 30,000 having medium-sized heads. 60,000 photographs are thus eliminated. The breadth of his head is B millimeters. He therefore belongs to the group of 10,000 who have small-sized heads. He has a middle finger measuring C millimeters in length. He therefore belongs to the group of about 3,333 who have long middle fingers. His foot is D centimeters long. He therefore belongs to the group of 1,111 who possess medium-length feet. His forearm measures E centimeters in length. He belongs therefore to the group of about 370 who have long forearms. His height is F centimeters. He belongs then to 120 short men. His brown eyes, the length of his little finger, and the height of the bust determine his position in that group, and finally his portrait may be found in a very limited number of specimens. Thanks to this ingenious process, it is possible to assert with mathematical certainty and in a few minutes whether or not the photograph of a particular individual is to be found among the 120,000 photographs. It is easy to understand that the most important and the most difficult thing connected with the work is to measure the 120,000 offenders. These measurements are dealt with in Part 1 of M. Bertillon's book. In Part 2 he deals with descriptive information: forehead, nose, ear, hair, beard, corpulence, etc., and in Part 3 with special characteristic marks. According to Bertillon, at least 5 of these should be given, as he maintains that every man has from 8 to 12 marks and characteristics. Whoever examines his own body will find at least so many. If attention is paid to all of these, a much more accurate, trustworthy, and lasting picture will be obtained than the best photograph. We give the following facts. The Paris police identify, on average, in the course of a year, 450 to 460 persons who but for anthropometry would remain unrecognized, or carry on their malpractices under false names. This makes about 4 cases in every 3 days. Bertillon goes yet a step further, and that an important one. With the help of what is called the portrait parlé, he teaches the police how to detect individuals who are at liberty with the greatest certainty even when they have much altered in external appearance. For a description of this method see Chapter 7, Section 1. The Bertillon method has now become so important that the idea of measuring the whole population over the age of 20 has been broached, not only for criminal cases, but for the identification of persons who are the victims of crimes, suicides, the insane, and insurance cases. It would be very valuable. End of section 41.
Section 42 of Criminal Investigation, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Criminal Investigation, a practical handbook for magistrates, police officers, and lawyers, Volume 1, by Hans Gross. Translated by John Adam and John Collyer Adam. The Expert and How to Make Use of Him, continued. Section 11. Fingerprints. A. Advantages over anthropometry. The adage that however good a thing is, it may be bettered, or displaced by something better, is very applicable to the Bertillon method of anthropometrical measurement. Thus it is that the newly revived idea of the utilization of fingerprints for identification purposes threatens to a great extent to take the place of anthropometry. With fingerprints and anthropometry combined, there should be little trouble in identifying an old offender. But the advantages of fingerprints over the Bertillon system have become so well established that it is doubtful whether the latter cannot with perfect safety be dispensed with altogether as unnecessary for purposes of identification. These advantages have been well set out in a memorandum published by the Dresden Investigation Department. 1. Anthropometry. 1. The instruments are expensive, easy to spoil, and only to be obtained from certain suppliers. 2. The persons who carry out the measurements must have had a special and complete course of instruction. 3. The measurements of the body can only be taken at appointed measuring stations and by appointed measurers. 4. If the measurements are not properly taken, or being properly taken are wrongfully read or transcribed, the mistake cannot be discovered at the office where the records are kept, and thus all chance of successful result is spoiled. 5. The taking of the measurements demands time, for to be reliable they must be repeated 3 times. 6. It is necessary for the body to be partly exposed. 7. The measurements of young people alter as they arrive at maturity. 8. Double search is often rendered necessary. 2. Fingerprints. 1. The necessary accessories, a piece of tin, a bit of india rubber, and printing ink, are above all cheap and easy to procure. 2. Any person can, after a half-hour's practice, take clear fingerprints. 3. The fingerprints can be taken by any policeman at any place. 4. To check a sequence of recorded fingerprints, the comparison of a single impression suffices. 5. The prints of the whole 10 fingers can be taken very much more quickly than body measurements. 6. It is not necessary for a person to remove his clothes. 7. The pattern of a fingerprint never alters during the life of an individual. 8. Mistakes being impossible, no second search is necessary. B. Practical application of fingerprints. Fingerprints are now in common use for the detection of criminals as well as the elucidation of criminal mysteries in nearly all civilized countries. They were first generally employed in India under the auspices of Mr. Henry of the Bengal Police, now Chief Commissioner of the London Police, who has naturally greatly promoted their adoption in England. Mr. Joseph Farndale, Chief Constable of Bradford, has also taken a leading part in encouraging their practical use in England, and most European countries have followed suit. It has been known for a long time that the lines on the fingers are different for each person, also that in the course of a year they may come together or go further apart, but if nothing in the shape of a wound has taken place, they do not really alter. Welker, the anthropologist, gives the impressions of the palm of his hand for the years 1856 and 1897, which fully confirm this. The fingertips of a mummy in the Natural Museum of Vienna show after thousands of years clear papillary lines. They can be seen on corpses that have lain in water for a week, the lines only disappearing with mortification. Even when the tip of a finger is lost, the new tip shows the same pattern, though of course transversal wounds disturb this. From the most ancient times, the Chinese have used the lines on the tips of the fingers of criminals for their identification. Sir William Herschel adopted this method in India in doing business with the natives instead of their usual signatures, and in the Indian Army fingerprints of the soldiers are always taken and preserved. Galton was the first to see the advantages of this system, and by his careful observation and collation of examples brought it into favor as a means of recognition of old offenders. Classification of fingerprints is not really difficult. With the help of a magnifying glass, the marks are examined in all possible ways and carefully noted down. It is seen that a line is broken or divides into 2 separate branches, or 2 lines come together to form one ridge. All points such as these afford excellent means of dividing the various classes of fingerprints, or identifying with greater certainty 2 pictures of the same finger taken at different times. And here we come to the kernel of the whole question. These remarkable signs, which appear on the body 3 months before birth, and after death only disappear with the final dissolution of the corpse, retain their formation unaltered during the whole lifetime. Take, for example, the two pictures of the forefinger of Sir William Herschel, the right-hand one dating from 1860 and the other from 1888. Although in the latter the lines are somewhat broader and fainter, yet the first glance shows them to be the same, and closer examination proves that the lines of the 1860 fingerprints are exactly the same as those of 1888. Galton compared at lengthy intervals the fingerprints of 8 persons, and at the first examination he noticed 296 particular points which he found exactly the same at the second examination. There is no possible doubt as to the durability of these signs. The dimensions may alter a little with time, but their character remains the same, just as a piece of lace can be twisted in all directions without damaging its original pattern. The accompanying plates have been kindly lent to the authors by the Madras government. They were issued with a government order upon the utilization of fingerprints in India, which contained a considerable amount of information on the subject. In explanation of the plates, the order stated as follows: "For the information of officers, who may have occasion to examine fingerprints with a view to verifying the identity of the individual from whose hands they have been taken, it is necessary to premise that the impressions recorded form clear and distinct patterns which are constant and ineradicable. Each individual's hand presents a separate set of impressions, which a slight scrutiny suffices to distinguish from the fingerprints taken from any other hand. Nor do the impressions taken from the same hand at different periods of life change with lapse of time, except, as has been remarked, for alterations, "such as would be found in lace, which, after being washed and stretched, will show the same pattern and number of meshes, although they may be somewhat distorted in shape." There are 3 main types of pattern, namely arches, loops, and whorls, specimens of which are shown in the accompanying Plate 2. The pattern is an arch, when the ridges in the center run from one side to the other of the bulb without making any backward turn or twist; a loop, when there is a single backward turn but no twist; and a whorl, when there is a turn through at least one circle. Loops on the fingers may further be distinguished as either inner loops, when they turn towards the thumb side, or outer loops toward the little finger (Plates 2 and 3). In the police department it is customary, for the purposes of classifying the fingerprints recorded in numerous cases, to assign a separate descriptive formula to each pair of hands, and the manner in which this is done is explained at length in Rules 10 to 13 of the revised edition of the Departmental Manual entitled "Anthropometry as applied to the identification of criminals." For the purposes of the present rules, it will, however, ordinarily suffice to examine each fingerprint either by the naked eye or with the aid of a magnifying glass, in order to ascertain if in each case the distinctive pattern corresponds with that noticeable in the impression previously recorded. Thus, supposing Plate 3, left hand, to represent the permanent record, it would be necessary to examine the new set of impressions in order to make certain that the pattern of the fourth or little finger was a loop, that of the third finger a whorl, and so on. A variation in any one case would be sufficient to leave no doubt that false personation was being attempted. Should the general patterns correspond, a closer examination may, if thought necessary, be made, either with or without a magnifying glass, in order to ascertain whether each line in a particular impression coincides in appearance with the corresponding line in the fingerprint forming the permanent record. To further illustrate these rules, Plates 4 to 6 appended have been prepared in the Office of the Inspector General of Police. Plate 4 exhibits impressions of the thumb and fingers of the right hand, taken with an interval of 2½ years. Plate 5 represents the corresponding impressions of the first and second fingers enlarged. Plate 6 is a skeleton chart of Plate 5, and shows the axes of the ridges with the points of reference numbered." Wint divides fingerprints into 4 main types of pattern, which he also calls loops, arches, and whorls, and composites. This is also the classification adopted in England. To these, arithmetical and algebraical values can be given, so that 1024 combinations can be made therefrom. These are the basis of a very learned system introduced by F.K. King of London. But not only are fingerprints of importance for identifying and classifying old offenders, but they are also of great value from another point of view, namely, the actual elucidation of particular crimes. It is to Mr. Joseph Farndale that elaboration of this branch of fingerprints is largely due, though, as already mentioned, Mr. E.R. Henry, Chief of the London Police, first brought the subject to the front in England, and the standard work on the subject is written by him, namely, The Uses and Classification of Fingerprints. It is now established that in the detection of crimes, too great value cannot be placed upon fingerprints, as the following cases cited by Mr. G. E. Mallet, Strand Magazine, May, 1905, will show. The first case was in the early part of the year 1905. An office in the chief street of the city of Bradford was entered by means of breaking a glass panel in the door, and money and stamps were stolen. In pulling out the glass from the door, the thief left a fingerprint on the glass, which was brought away, photographed and enlarged. Suspicion fell on a person whose fingerprints had previously been taken, and on the file being searched, his left thumb was found to be identical with the impression on the glass. In another case, several burglaries had been committed in the district. The property stolen was of a kind which could not be readily identified, chiefly cash. After several of these robberies had passed undetected, there came at length an instance where a small polished wood box, used to contain homeopathic medicines, had been removed from its customary position. In consequence, this box was carefully examined, and the lid was found to bear a finger impression, which was photographed. A person was suspected of the offence who had previously been in custody, and it was natural, of course, at once to proceed to enlarge the finger impression on the medicine box, and compare it with the registered impression. When it was found that the impression on the box was identical with that of the suspected person, orders were issued for his arrest. A number of incriminating circumstances appearing against him, he was convicted. In a case, in September 1904, a beer bottle played an important part. Cash was stolen from a club in Bradford. The thief got in through a window, and had helped himself to a bottle of beer. The fingerprint on the bottle was very obscure indeed, but after being chemically treated, photographed, and enlarged, it came out clear enough for the purposes of identification. Suspicion fell on a sailor who had been observed by the police in the district. Circumstances led to his arrest, and he failed to account for some money. He was remanded, and his fingerprints were taken. His right middle finger corresponded exactly with the impression on the beer bottle. In passing, it should be noted with regard to this case that without the fingerprint it would have been impossible to obtain a conviction. See Plates 8 and 9. The next case is not without its humorous element. Two men were found in possession of a quantity of stolen property. They were arrested on suspicion. Their explanation was that the property had been given to them by a man unknown to carry away. Inquiry was made, and it was found that the articles had been taken from the house of a minister who was away on his holidays. The thieves had got into the minister's residence by removing the slates over the bathroom. After getting through the ceiling of the bathroom, they let themselves down onto the floor below by means of the bathroom door, which stood open. In doing so, some fingerprint impressions were left on the top of the door. One impression was a very plain one. The bathroom door was taken bodily but very carefully from its post. The door, 7 feet high, was treated with the utmost respect, and, protected by paper, was conveyed on a cart to the town hall, where it was carried up to the detective studio and photographed. The last case cited by Mr. Mallet is perhaps the most remarkable of all. It was reported to the police on a Sunday that the premises of a well-known bowling green club in Bradford had been entered on the Saturday night, and some 500 bottles of whiskey and other liquor had been carried away to an adjacent wood. The customary careful examination of the premises showed that the thieves had been helping themselves to whiskey. Apparently only one vessel had been used, a small tumbler of thin glass. On this there was a fingerprint, very faintly discernible. The fingerprint was chemically treated with hydrofluoric acid, photographed and enlarged. Considering that the impression was upon glass, it was wonderful how clearly the ridges of the finger were eventually reproduced. The impression was evidently of the whorl type. There was no clue of any kind in this case. But in looking at the register, the impression of the finger of a man was found who had been remanded some time previously for another offense, but had been discharged. In this case, the man whose fingerprint was on the glass was at once arrested, and when he was charged with the robbery, confessed to being guilty, and he gave information to the police which enabled them both to arrest another man implicated and to recover part of the stolen property. See plates 10 and 11. One of the most remarkable murder cases of modern times was the trial of the brothers Stratton, accused of a crime which took place on the 27th of March, 1905, and became known as the Mask Murders. An old man and his wife were brutally murdered one night in their shop, and their cash box rifled. All that was left behind by the burglars were 3 masks very roughly made from the tops of stockings, and a fingerprint on the tray of the cash box. This was the first time fingerprint evidence was ever submitted in an English murder trial, and the criticism with which it was received is interesting. Enlargements of the photographs taken of the fingerprints found on the cash box, and Alfred Stratton's right thumb, were produced by the police inspector, while copies and magnifying glasses were handed to the jury to enable them to follow the parallel characteristics of identity that the officer pointed out on a large chart which he held up. He asserted that he could find no characteristic visible in the print on the cash box which did not agree with Alfred Stratton's thumb. In cross-examination, the inspector said, that in points, which he could not agree with counsel were discrepancies, the pressure applied by the digit would play a large part. It was only a mark of perspiration and dust on the cash box, and a mark made on evenly distributed ink in the other. Pressure would give a curved line in the one, and lack of pressure a straight line in the other." It was pointed out to the inspector, by the aid of the compasses, that the distances between certain points of identity relied on by the witness varied as much as the 1/12 of an inch on the cash box print and Alfred's thumb print. The inspector explained this by saying that the 2 enlargements were on a slightly different scale, and he added that as they were 13 times the natural size, the difference of 1/12 of an inch would have to be divided by 13, and so would be infinitesimal in the original prints. Fingerprints of the dead couple, and of all who were in the habit of being in the house, were also presented to the jury to show that the fingerprint on the tray of the cash box could not possibly be theirs. The judge, in summing up, said that, as to the fingerprint identification, where the prints were taken for the purpose of identification of a criminal whose impressions the police already possessed, the system seemed to be extremely reliable. But it was a different thing to apply the system to a casual mark made by the perspiration of the thumb on an object. You could not expect that it would correspond with the same degree of accuracy. It would be blurred, and the other taken from the suspect would be clear. So it was in this case. Consequently, the judge continued, "This is not so satisfactory as it would have been if you could suppose the murderer had a pot of ink and made a definite impression. But there is one thing that is clear about this. If it is true that people's fingers do vary so much as has been described, there is an extraordinary amount of resemblance in the 2 photos, and to a certain extent it is corroborative evidence. None of you, I should think, would like to act on this alone. The point is not whether you will go on this alone, but the point is whether it is not substantial evidence corroborating the other statements that Alfred Stratton must have been one of the men on the scene of the murder." Both prisoners were convicted, sentenced to death, and executed. The law as to the judicial use of finger impressions in India is contained in the Evidence Act, Section 73, as amended by Act 5 of 1899. Thus amended, the section reads, "In order to ascertain whether a finger impression is that of the person by whom it purports to have been made, any finger impression admitted or proved to the satisfaction of the court to have been made by that person may be compared with the one which is to be proved, although that finger impression has not been produced or proved for any other purpose. The court may direct the finger impression of any person present in court to be taken for the purpose of enabling the court to compare the finger impressions so taken with any finger impression alleged to have been made by such person." It is clear two questions arise. 1. What does identity of impression prove? Here the expert gives unimpeachable evidence that identity of impression means identity of person. 2. Does such identity exist? Here the expert can do no more than point out the grounds on which his opinion, as to identity or non-identity, is based, leaving the jury or the magistrate to draw his own conclusions from this, as from any other evidence. The point is best illustrated by example. We accordingly quote the relevant portions of an appeal heard in the Calcutta High Court, 24th March, 1905, CILR 32, Calcutta, page 759. The accused, Abdul Hamid, was alleged to have falsely personated one Mashraf Ali, and in such assumed character to have admitted the execution of a bond purporting to have been made in favor of one Guran Ali, his cousin's husband, and to have presented the same for registration on the 5th November, 1902, before the sub-registrar of Anhungagar. It appeared that on the 11th instant, the real Mashraf Ali went to the sub-registrar and lodged a written complaint before him that some person, not named, had falsely personated him and got the said bond registered, upon which an inquiry was held resulting in criminal proceedings being instituted against the accused and certain others. During the trial, one Mohammed Amin, a sub-inspector in the Criminal Investigation Department of the Inspector General of Police, was examined as an expert on fingerprints, and he deposed that the thumb impressions on the forged bond, and in the sub-registrar's thumb register, corresponded with the thumb impression of the accused, taken before the magistrate, but not with that of Mashraf Ali. The jury returned a unanimous verdict of not guilty, whereupon the judge put to them the following question. Question. Do you find that the thumb impressions exhibit 1D on the bond is not the impression of the accused? Answer. We are not ready to accept the evidence of the expert as conclusive. We do not think he is properly qualified to give an opinion. The judge, disagreeing with the jury, referred the case to the High Court under Section 307 of the Criminal Procedure Code on the ground that their verdict was perverse." In the course of their judgments the following remarks were made by the judges. Henderson J. The only other evidence which reference may be made is that of Mohammed Amin, a special sub-inspector on 30 rubles a month in the Criminal Investigation Department, who was brought down from Calcutta to give evidence as an expert as to the correspondence between the thumb impressions of the accused with those on the bond and in the thumb impression register kept at the registry office. He said that he had studied finger impressions for 5 months in a training school and 13 months in the office of the Inspector General of Police, and that he examined 2 or 3 lakhs of impressions and had himself taken thousands of impressions. He was of opinion, apparently without any reservation, that the thumb impressions made in court by the accused corresponded with those made by the person who presented the bond, on the bond itself and in the thumb register. He gave his reasons for his opinion, stating the various points of similarity, and his opinion is, therefore, entitled to be treated with very great consideration. I have myself subjected the impressions to a careful study, both with the naked eye and a magnifying glass. The impressions are unfortunately blurred, and many of the characteristic marks are, therefore, far from clear. This renders it difficult to trace the marks enumerated by the expert witness as demonstrating the correspondence between the two sets of impressions. I am unable to say more than that in some respects a distinct similarity can be traced. Under these circumstances, I should hesitate to say that the jury were wrong in not accepting the evidence of the expert, more especially when the evidence to corroborate his testimony was of such an unreliable character. xi.J. The Sessions Judge, however, is of opinion that the evidence of the Sub-Inspector from the Inspector General's Criminal Investigation Department is quite sufficient to fasten the personation on the accused. The Sub-Inspector took an impression of the accused thumb before the committing magistrate, it is marked Exhibit 4, and professing himself an expert, he declares that this impression is made by the same person as the impressions, marked Exhibit 1D and Exhibit 2, made on the document and the register. If this evidence be accepted, it would corroborate the testimony of Kabel Krishna and put it beyond reasonable doubt that it was the accused who presented the document and admitted its execution. The jury have, however, declined to regard the sub-inspector as an expert, and to act on his opinion, and it is necessary for us to consider whether they were wrong in so doing. Now, though the classification of finger impressions is a science requiring study, and though it may require an expert in the first instance to say whether any two finger impressions are identical, yet the reasons which guide him to this conclusion are such as may be weighed by any intelligent person with good powers of eyesight. In the present case, the sub-inspector has enumerated 9 different marks by which he has come to the conclusion that Exhibit 4 is the impression of the same thumb as Exhibits 1D and 2. I have examined these impressions for myself with the aid of a magnifying glass, and endeavored to test the sub-inspector's reasons. His first reason is that the pattern in the two sets of impressions is the same, and his fifth is that the central core or ridge is the same. These reasons can readily be verified by a comparison of the impressions, but they do not carry us very far, for it is obvious they may coexist in the thumb impressions of many different persons. With these 2 exceptions, I have been unable to identify the marks enumerated by the witness as existing in the 2 sets. For instance, the sub-inspector's second reason is that the number of ridges between the right delta and the inner terminus is the same. The sub-inspector has not mentioned the number of ridges thus indicated, and they are so blurred and run together that I am unable to count them for myself. The sub-inspector's third reason is as follows. The 5th ridge below the right delta ends abruptly, also the 7th ridge ends at the same point as the 5th ridge, the 3rd ridge bores a little way and then stops. I am able to follow these features in Exhibit 4, but cannot distinguish them in Exhibit 1D or in Exhibit 2. I need not go in detail through the other distinguishing marks. It is sufficient to say that, though I can often perceive them in one impression, generally Exhibit 4, in which the ridges stand out the clearest, I am unable to say that they exist in the other impressions. The sub-inspector is a person who failed for his B.A. examination, and has been only a little more than a year in the police. Considering the difficulty I have in perceiving the marks which led him to say that the impression marked Exhibit 4 is made by the same person as Exhibits 1D and 2, I cannot say that the jury were wrong in declining to regard him as an expert, whose opinion they were bound to accept without the corroboration of their own intelligence as to the reasons which guided him to his conclusion. In making these observations, I desire to throw no doubt on the science of finger impressions, or on the validity of the conclusions which may be established from a similarity in their marks. But in the present case I am of opinion that the similarity of the 2 sets of finger impressions has not been established, and as the remaining evidence is far from cogent, I would refuse to disturb the verdict of the jury." End of section 42.
Section 43 of Criminal Investigation, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Criminal Investigation, a practical handbook for magistrates, police officers, and lawyers. Volume 1 by Hans Gross. Translated by John Adam and John Collyer Adam. The Expert and How to Make Use of Him. Continued. Chapter 9c. The Manner of Recording Fingerprints. The examination of fingerprints is no easy matter. It is therefore above all necessary that good and true impressions should be taken, which can be kept and compared with others. To make true and sharp copies containing no gaps, Galton gives two methods. Firstly, a sheet of glass or metal plate may be covered with lamp black and a fingerprint made thereon. At all parts touched by the elevations of the skin, the lamp black comes off. The second method is the one now generally adopted. The finger is placed on a metal, glass, or porcelain plate on which black printer's ink has been spread as smoothly as possible, and the impression is then taken on a piece of paper. The ink adheres to the elevations of the skin, which are thus reproduced on the paper. The difference between the two methods is that in the first, it is the hollows of the finger which are reproduced, whereas in the second it's the elevations, thus in a manner resembling the negative and positive of photography. The latter method is certainly the best and easiest. The following are the rules laid down by the Indian government for the taking of fingerprints. Quote, "The apparatus required for taking impressions consists of the following articles: a sheet of tin or copper 10½ inches by 7, or of such other size as experience may show to be most convenient, screwed down by its corners to a board 1 inch thick, an ordinary printer's roller, and a tin of printer's ink. Both roller and slab must be thoroughly cleansed with kerosene oil on each occasion after use, dried with a rag, and put out of the way of dust. The manner in which impressions should be taken is explained below. 1. Squeeze a drop of ink on the plate and work it with the roller till it forms an even layer over the surface. The ink must be so thin as to allow the color of the plate to show through it. 2. Then take the little finger of the left hand, roll the bulb slightly on the inked slab and roll it again on the paper in the space marked for that finger. Do the same with each of the other fingers and thumb in succession, so that the imprints of them may be taken in their allotted places on the paper. Note: a drop or two of kerosene oil added to the ink makes it more fluid. The inked finger should only be rolled once on the card from one side to the other and then removed cleanly without smudging the pattern. To afford clear scope for identification, the whole of the finger or thumb between the tip and first joint must be impressed. End of quote. Section 12. Geometrical Identification. W. Matthews, British Journal Almanac, 1890, page 412, makes an ingenious proposal. According to him, photographs may establish the identities of persons with absolute certainty, even after the lapse of a number of years since the time when the last photographs were taken. His system is based on the no doubt accurate idea that certain dimensions of the face of an adult human being do not change, if, at all events, there have been no illnesses or injuries to the skull in the meantime. The photographs to be compared are first very greatly enlarged, and in the same proportions. The greater the enlargement, that is to say, the larger the photographs to be compared are, the more decisive will be the proof, for the errors of measurement which may be committed will be of less importance. Next, a fundamental line, figure 9, is drawn through the pupils of the eyes, OO. The distance separating the middle of the two pupils is divided into two equal parts. Through this dividing point a perpendicular AA is drawn, and two parallels are drawn thereto through the pupils, BB and CC. Finally, parallels are drawn to the fundamental line OO, above and below that line as far as the chin and the roots of the hair. These parallels are numbered 1, 2, 3, etc. The distance between the horizontal lines is exactly the same as the diameter of the iris, that is to say, of the pupil of the eye on the picture. The verification of identity may be done in two ways. First, the two portraits are cut into two pieces along the line AA, and the halves of each are interchanged. If the portraits are of the same person, all the other lines will fit. 2. The two portraits, unmounted, are placed one upon the other so that the lines OO and AA coincide. If the portraits are identical, the other lines will also coincide. This method is to be recommended in important cases. End of section 43.
Section 44 of Criminal Investigation, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Availle in October 2014. Criminal Investigation, a Practical Handbook for Magistrates, Police Officers and Lawyers, Volume 1, by Hans Gross. Translated by John Adam and John Collyer Adam. Chapter 6. The Legitimate Sphere of the Public Press. It is natural for the investigating officer to find it impossible to escape from the influence of the great public press. We have therefore to discuss the position he ought to take up as regards that influence and in what way it may be of service to him. The connection between the investigating officer and the press is based upon a community of interest. The investigating officer is interested in crime and everything connected with it, and the daily press is interested in great measure in the same questions. An experienced journalist who had accurate information of what the public preferred to read in its daily paper once furnished the following list in which the heads are arranged in order of importance. 1. Births, deaths, marriage and divorce. 2. The reports of crime and criminal trials. 3. Local news. 4. The serial story, the theatrical news, the short story. 5. Special telegrams, political communications, leading articles. 6. Scientific notes and reviews. From this list it may be seen how much people are interested in communications relating to crime, and as the interest of the public is the interest of the journalist, the place of honor is given to these communications. The experienced and expert journalist would rather give up every other article in his paper than the first report of a criminal case. And this is where he finds himself in conflict with the law, for in all civilized states the precipitate divulgence of details connected with judicial cases is considered to be more or less illegal. True it is that there are few laws more often broken than those of which we speak. Every day we read in the paper exact descriptions of crimes which have just been committed, especially when these crimes are particularly outrageous and horrible. How much truth can be found in such reports is another question, More than one of us have been unable to help saying to ourselves on reading these newspapers' reports, "I seem to have heard of a case like that." So much had the case brought to the notice of the investigating officer on the previous day been disfigured. It is easy to understand how this comes about when we observe the manner in which the news given by the paper is fabricated. The investigating officer and his assistants have sworn to guard their professional secrets, and in every crime the manner in which it has been committed is considered to be relevant to the matters to be embraced by this professional reticence. In consequence of this, the investigating officer and his auxiliaries wrap themselves in the impenetrable mantle of secrecy and tell the journalist nothing. The reporters therefore fall upon the watchmen, the witnesses and their relations, upon the jailers of the prison, upon the cabman who has driven the investigating officer to the scene of the crime, upon the people of the house, and upon other persons who have or may have some knowledge of the matter, and then compose their narrative, a narrative said to be worthy of all belief. We may cite the case of a reporter who, with particular cunning, had entered into the closest relations with the housemate of the investigating officer, in order to learn from her what her master related to his wife at table with reference to interesting cases. In this way are those horrible descriptions which overflow our newspapers fabricated, of which we legal gentlemen take no notice, saying, "These newspaper reports are all quite indifferent to us." But they are not in reality so indifferent, and, if regarded more closely, we must be convinced that these inaccurate reports do harm. In the first place, falsehood in itself is evil, and for that reason alone ought not to be tolerated. The importance and power of the press are far too great not to persuade us that it causes an immense amount of prejudice by furnishing continually, as it does, inaccurate statements of facts. We must moreover consider the influence which the report may exercise upon all those persons who have something to do with the case, be it intimately or remotely. Whoever has seen or heard something of the case in question takes a particular interest in it. Every such man gives himself an absolutely excessive importance, and whenever an individual's eyes fall by chance upon a list of names among which he finds his own, and his attention is, as we are sure it will, be first drawn by that name, he will become particularly interested in the case, for he has taken some part in it. He reads minutely everything connected with it, and everything which he knows better than anyone else. But, if he has some real knowledge of a case, he will be called as a witness, and will be no longer able to depose with an unbiased mind, since he has read inaccurate reports. Not only the man in the street, but investigating officers themselves have a certain confidence in everything in print, and allow themselves, in spite of many disillusions, to be influenced by newspaper articles. There must be some truth in it, one thinks, and if one reads several times over the account of the case, otherwise than as one has seen it oneself, one ends by doubting oneself, and, in spite of the best will to speak the truth, one gives an account of the case different to what one would have given if not under exterior influence. Newspaper reports, moreover, induce the public to form a definite opinion upon the case itself, and upon the culpability of the author of the crime, so that the verdict is often pronounced by the public long before the competent authorities have delivered their judgment. The official verdict, once given, is no longer in agreement with public opinion, which latter was based on erroneous information. Moreover, the public does not change its opinion, even in view of the light which is shed during the hearing of the case. The decision of the authorities is criticized, and it is not necessary to set out the bad effect of everything which is calculated to disturb the confidence which ought to be placed in the powers that be. This tendency of the press has in quite recent times, and particularly in London and New York, attained the dimensions of a public scandal. Trial and conviction by the halfpenny journal has more terrors to the criminal than the Old Bailey itself. The only thing that restrains these journals is the fear of proceedings for contempt of court, or actions, civil or criminal, for defamation. In India no such check is, as yet, recognized, for putting aside the half-score or so of leading papers, there is hardly an issue of a journal in India that would not in England lead the editor and publisher promptly to the bar of the courts. The only means of remedying this evil is to allow the investigating officer to himself communicate the essential matters concerning criminal cases to the newspaper. The latter on his part would be compelled to keep silent upon all the other details of the case. There seems to be an air of censure about this, but in reality it is not so bad as that. In the first place, we do not mean that the question should be regulated by law, for we imagine that it will be generally very easy to come to an agreement upon this subject with the reporters of the local paper, even in a large town. The investigating officer would provide the reporters with the news in question, while the latter would engage only to print the communications of the former, and to insert on their part everything which the investigating officer desires to make public. The tact of the investigating officer will guide him in what should be printed in a given case, and how and when it should be published. We do not desire by any means to advise the investigating officer to give the papers inaccurate information in order to baffle the unknown criminal or inspire his accomplices with confidence, etc. But it is not necessary to tell all that one knows or all that one suspects, or, if one wishes to tell it, the propitious moment must be awaited. The manner in which what may be told should be told is not, speaking generally, easy to indicate, and it is not even easy to express it in a particular case, but it is possible to find the correct method by taking into account all the circumstances accompanying the crime. The best way to proceed will be for the investigating officer to himself write out the note for the paper without long hesitation or reflection, and then consider the consequences which it will have from the point of view of the author of the crime in the event of his reading it, the same applying to the accomplices, witnesses, etc., if they come to know of it. At the moment when the note is drawn up, the general turn of the case will be fairly well known, and after a little reflection the effects of the note will also be guessed. More than one success in important criminal cases may be traced entirely to the use that has been made of a newspaper, but on the other hand it is also certain that one is exposed to very great dangers when an awkward use is made of the press. Here is an example of this. In a case of murder accompanied by theft, it had been possible, owing to a series of fortuitous circumstances, to describe very accurately, immediately after the crime, a number of the articles stolen, although the murdered person lived all alone and had no dealings with the world. It was supposed that the author of the crime, then still unknown, was well aware of this peculiarity of the woman in question, and would not fear to sell the stolen articles at the earliest possible moment. In order to rapidly inform the pawnshops, the investigating officer resolved to publish at once the description of such of the stolen articles as were accurately known, and succeeded in doing so in the evening papers, although the murder had only been committed on the morning of the same day. But this publication had a contrary result to what had been anticipated, for the author of the crime had, extraordinarily enough, got rid of no article that morning, and it came out later on that it was only in the evening, after the papers had appeared, that he sold such of the stolen articles as had not been described in the evening papers. In this case it would have been much better to have kept back the description. On the other hand, those mysterious airs so often affected by the authorities are quite ridiculous and often harmful. One will be doing the right thing if one takes into account the consequences which the divulgence of information may have. If there is no adequate reason to suppose that this divulgence will have had consequences, there need be no hesitation in speaking out. But special care must be taken that the information published is accurate. The following cited case shows this. It is also an interesting example of the value of unprofessional expert advice. Chapter 5, Section 1. Quite recently in London, a lady committed suicide by poisoning in a West End hotel. The Morning Leader in its report says, "She took the greatest care to destroy every possible trace of her identity, even to buying new clothes and underclothes which bore no apparent mark of any kind. But she missed one little detail, the red thread figuring on her dressing jacket. This mark was given out at the inquest as a laundry mark. xi.A-B. Those letters have been published far and wide, in England, France, Germany, and in America. Hundreds of laundry keepers have been interrogated with xi.A-B as a clue to work upon. After a lapse of days, the president of the Laundry Association has come forward and has proved, after his expert examination, that with the exception of the E, these supposed letters are numbers stitched in angles. He therefore reads the inscription thus, E48.992. There is a possibility that the last figure may be an O, but in his experienced eye the others are plain. He is convinced that they do not form a laundry mark, because laundry people never use so many figures. He thinks that the mark is a dyer's and cleaner's mark. Thus, says he, it is certain that this row of figures has been entered, as a reference, in the books of some dyer and cleaner's firm, and it is possible that the name and address of the owner of that jacket may be entered alongside. When the investigating officer succeeds in obtaining the goodwill of the reporters, he can in return for his complacency expect many kindnesses when dark days arrive. The investigating officer often finds it necessary to have official notes published, but official advertisements have this peculiarity that no one reads them, especially those persons whom they most concern. But if these publications are inserted among the general news of the day, they are read with avidity and their object is attained. The discovery of witnesses and of the owners of the various articles, questions concerning such a state of affairs or such an event, invitations to come and inspect certain articles in the possession of the investigating officer, the search for people who have disappeared, and 1,000 other similar communications which would fill up without result the police gazettes and papers, would have some chance of success if they appeared in the public press under the head of actualities. When important matters are in question, a few words may be added to the note requesting other papers to notice it in their columns. In such cases, the press is for the most part quite ready to assist justice, especially the more important and better class of paper. On one occasion, for example, persons a long way off were placed in a position to give information in a case about which a note had appeared in a small country paper. This note found its way to the principal papers of the capital, and finally even American papers, which had reproduced it, were received. Some of them indeed had added a few words to the note embodying the assurance that they had been happy to be able to serve a good cause. And, what is more important from a fiscal point of view, all this costs the state absolutely nothing. But in order for the investigating officer to be able to make use of the press, he must not only hold the journalists in hand and proceed with tact, but he must also be allowed complete and entire liberty by the authorities. The latter ought to know whence these notes originate, and that the investigating officer is conducting the case as it ought to be conducted, and not come down upon the paper some fine day for the premature divulgence of secrets which are considered to be harmful to the investigation. End of section 44. End of Criminal Investigation, a Practical Handbook for Magistrates, Police Officers and Lawyers, Volume 1, by Hans Gross. Translated by John Adam and John Collyer Adam.